So, Donald Trump just suffered what legal experts are calling the most devastating 24-hour period of his post-presidency legal battles, with federal appeals courts across the country systematically dismantling his defense strategy in coordinated fashion. We're talking simultaneous rejections in 3 separate circuits, judges using language like frivolous and constitutionally indefensible, and here's the kicker that nobody saw coming. Warren Buffett, the Oracle of Omaha himself, who stayed out of Trump controversies for years, just went on CNBC and basically said the quiet part out loud about what this means for American business confidence. It's honestly hard to believe we're watching this unfold in real time. This isn't just about one politician's legal troubles anymore. We're talking about whether someone can just ignore court orders, burn through appeals like they're going out of style, and operate as if the judicial system is optional. And trust me, what happened this week is going to reshape the entire 2024 landscape in ways most people haven't even begun to process. Let me fill you in on what's been happening behind the scenes. So Donald Trump has built his entire post-presidency strategy on a pretty simple playbook. When you get hit with legal trouble, you appeal everything, delay everything, and hope the system gets exhausted before you do. It's worked for him in business for decades. File for bankruptcy, tie things up in court, outlast your opponents. And for a while there, it seemed like he could pull off the same trick with these criminal and civil cases piling up against him. His legal team has been filing appeals on everything from document handling to financial fraud to election interference. The strategy was crystal clear. Keep everything in the appeals process until at least past the 2024 election, maybe longer. If he wins the presidency, well, the whole Justice Department works for him again. If he loses, at least he's bought himself years of freedom while cases wind through the system. But here's where the rubber meets the road. According to reports from Politico and CBS News dated October 22nd and 23rd, something unprecedented just happened. Within a 24-hour window, the Fourth Circuit in Virginia, the 11th Circuit in Georgia, and the D.C. Circuit all issued rulings rejecting Trump's appeals in 3 separate major cases. We're talking about cases involving classified documents, financial fraud, and election interference charges. 3 different circuits, 3 different legal teams, 3 simultaneous rejections, and the language these courts used wasn't the usual careful judicial hedging. Judge Raymond Kethledge, a conservative appointee who's typically measured in his opinions, wrote that Trump's appeals were lacking in legal merit to the point of frivolity. That's federal judge speak for, you're wasting everyone's time. Then came the moment that really sent shockwaves through the financial and political world. Warren Buffett, who has studiously avoided commenting on Trump's legal situation for years, sat down with CNBC's Becky Quick and delivered what can only be described as a devastating assessment. He said, and I'm quoting directly here, when you see the appeals process being used not as a legitimate legal tool, but as a delay tactic, and when that becomes obvious to the markets and the courts, confidence erodes. That's not good for American business, and it's certainly not good for the rule of law that underpins our entire economic system. Coming from Buffett, who manages hundreds of billions and whose words move markets, that's not just commentary, that's a signal. And before we go any further, let's be real for a second. This isn't about rooting for or against any political figure. This is about understanding what happens when the appeals process, which exists for legitimate legal disputes, gets weaponized as a delay mechanism. Now, back to the matter at hand. Reports from around October 23rd revealed just how significant these coordinated rejections actually were. The Fourth Circuit's ruling came first, early morning, in the classified documents case. Judge Barbara Milano Keenan, writing for a unanimous 3-judge panel, stated that Trump's legal team had failed to demonstrate any reversible error in the district court's denial of dismissal motions, and went further to note that the arguments presented border on the frivolous and appear designed solely to delay proceedings. Talk about strong words. Essentially, the court was calling out Trump's entire legal strategy as a stalling tactic, not a legitimate appeal, and this wasn't a private conversation between lawyers. These rulings are public record, published for everyone to see, making it absolutely clear that the judiciary is done playing games. This announcement sent immediate ripples through Republican donor networks because it raised a critical question that nobody wanted to ask out loud. If Donald Trump, with all his resources and legal firepower, can't win a single appeal across 3 different circuits, what does that mean for his actual legal position? How weak must the underlying cases be for the defense if experienced federal appellate judges are using terms like frivolous? Now, this isn't the first time we've seen Trump burn through allies and institutions that stop serving his immediate needs. Trump's loyalty really only extends to people while they're useful to him. Whenever someone stops being an asset or does something he doesn't approve of, he's quick to turn on them, and we've spotted this pattern over and over again. Just think about how he turned on Jeff Sessions right after Sessions recused himself from the Russia investigation. Sessions had been one of Trump's earliest Senate supporters, a loyal soldier who stuck his neck out when other Republicans were hedging their bets. But the moment Sessions followed legal ethics rules and recused himself, Trump spent 2 years publicly humiliating him, calling him weak, eventually forcing him out as Attorney General. Sessions' reward for decades of conservative legal service was public disgrace and a destroyed political career. Then there was Bill Barr. Barr had been Trump's most aggressive defender as Attorney General, the guy who spun the Mueller report, who backed Trump's most controversial positions, who seemed willing to use the Justice Department as a political shield. But when Barr finally said there was no evidence of widespread election fraud in 2020, Trump turned on him immediately. Called him a coward, suggested he was compromised, basically erased 2 years of loyalty because Barr wouldn't lie about election results. Barr went from trusted ally to persona non grata overnight. And let's not forget how he completely abandoned Mike Pence when Pence refused to overturn the election results on January 6th. Pence had spent 4 years as the most loyal vice president imaginable, defending every Trump position, never contradicting him publicly, standing by him through every controversy. But when Pence followed his constitutional duty and certified the election, Trump threw him to the wolves. Literally. While a mob was chanting threats against Pence, Trump was tweeting criticism of him. That's the level of loyalty Trump shows to even his most faithful allies. Even Kevin McCarthy faced a similar fate when he tried to navigate between Trump's demands and the practical realities of running the House. McCarthy bent over backwards to accommodate Trump, visited Mar-a-Lago, defended him against impeachment, but when McCarthy needed Trump's help to save his speakership, Trump was nowhere to be found. Now it looks like Trump's own legal strategy is getting the same treatment. The courts are done indulging him. This pattern has become crystal clear. You can show all the loyalty in the world and defend Trump every single day, but the moment you step out of line or cease to be useful, he'll toss you aside without a second thought. And now the same dynamic is playing out with the judicial system itself. So what led to this unprecedented wave of rejections? Well, it all boils down to Trump's legal team flooding the system with appeals that courts increasingly view as meritless delay tactics. Here's where things get interesting. The legal situation broke down like this. Trump's attorneys wanted to appeal virtually every adverse pretrial ruling, every denied motion to dismiss, every procedural decision that didn't go their way. The goal was obvious: create so many layers of appeals that trials couldn't actually start until well after the 2024 election. Meanwhile, prosecutors across multiple jurisdictions were arguing that Trump was abusing the appeals process, that most of these appeals had no legitimate legal basis, and that the courts needed to move forward. Ultimately, trials kept getting delayed as appeals stacked up, which is exactly what Trump's team wanted. As the person facing multiple criminal indictments, Trump's initial strategy seemed straightforward. He would appeal everything aggressively, file emergency motions, seek stays of proceedings, and basically throw every possible legal obstacle in the path of prosecutors. His approach appeared to be delay, delay, delay until after Election Day 2024. At first, this strategy seemed to have some success. Cases did get delayed, trials got pushed back, and Trump managed to avoid any courtroom reckonings during the crucial primary season. But here's where things started to go wrong. As these appeals dragged into their 3rd and 4th months, some serious issues started cropping up. Courts were getting backlogged. Prosecutors were filing increasingly pointed briefs about abusive process, and judges were running out of patience with what they saw as frivolous filings. While Trump's team was churning out appeals, the appellate courts began to notice a pattern. These weren't serious legal arguments raising novel constitutional questions. They were recycled arguments, procedural technicalities, and desperate attempts to find any basis for delay. Poll data from YouGov in early October showed that 61% of Americans, including 34% of Republicans, believed Trump was using the legal system to avoid accountability rather than defending himself on the merits. This was the moment when even some conservative legal voices began expressing concern. You see, Trump values winning, maintaining control of the narrative, and above all, avoiding personal consequences. He doesn't want to be the defendant who exhausted every judge's patience, who got slapped down by courts across the political spectrum, who became the poster child for abuse of the appeals process. That's definitely not the strongman image he's cultivating. And then Trump's legal team made what multiple experts are now calling a catastrophic strategic error. They simultaneously pushed for emergency stays in all three circuits, essentially asking different courts to halt proceedings based on virtually identical arguments. The legal community saw this as forum shopping taken to an absurd extreme. When the Fourth Circuit not only denied the stay but issued a blistering opinion calling out the delay tactics, it set off a domino effect. The 11th Circuit followed within hours with an even stronger rejection. The D.C. Circuit piled on with language that legal experts described as unusually pointed for an appellate opinion. But when news of these coordinated rejections broke, Trump's team went into what Politico's sources described as crisis mode. One anonymous source close to the legal team told reporters they were blindsided by the speed and unanimity of the rejections. Conservative legal expert Andrew McCarthy, writing for National Review on October 23rd, stated that if the appeals courts are this unified in rejecting these arguments, it suggests the underlying legal position is far weaker than Trump's public statements suggest. This is not a good sign for the defense going forward. Now, this left Trump in an absolutely impossible position. On one side, he desperately needs these cases delayed past the election because criminal trials during a presidential campaign are political poison. His entire electoral strategy depends on being able to campaign as a victim of political persecution, not as a defendant actively sitting in courtroom facing evidence. If trials proceed, he's looking at weeks or months where he can't campaign, where damaging evidence gets aired daily, where the news cycle is dominated by prosecutors laying out criminal allegations. The MAGA base might stick with him, but swing voters in Pennsylvania, Michigan, Wisconsin, Georgia, Arizona, and Nevada, the states that actually decide elections, those voters have consistently shown in polling that they're uncomfortable with voting for someone actively on trial for felonies. On the flip side, he actually needs some legal wins to maintain credibility with donors and maintain the persecution narrative. That means his lawyers need to make legitimate legal arguments that courts might actually accept, which requires stepping back from the scorched earth delay tactics and actually engaging with the merits of the cases. The tricky part is that genuinely engaging on the merits means acknowledging that prosecutors have evidence, that there are serious legal questions to address, and that Trump's actions might actually have been legally problematic. So Trump is caught in a bind. He can either keep filing appeals that courts increasingly view as frivolous, which means more rejections like we just saw, more judges using words like lacking in merit and designed solely to delay, and that only strengthens prosecutors' hands and makes Trump look desperate and legally weak. Or he can have his lawyers actually engage on the legal merits, acknowledge that there are tough questions to answer, and hope for favorable rulings on narrower grounds. But that definitely invites earlier trial dates and makes him look less like a victim and more like a defendant with something to answer for. It's a tough situation. And here's the thing. Trump created this mess for himself by treating the appeals process as a delay mechanism rather than as a legitimate avenue for legal review. He demands absolute loyalty from his legal team and wants them to fight without any concession to reality, but then he attacks them publicly when courts reject their arguments. He's not shy about throwing lawyers under the bus whenever it suits his narrative. This whole scenario is causing major fractures within Republican circles, and here's where Warren Buffett's comments become especially significant. If Trump's own appointed judges and conservative-leaning courts are rejecting his appeals, and if respected business figures like Buffett are publicly expressing concern about the rule of law implications, every major Republican donor is left calculating whether Trump can actually win a general election while facing these legal problems. Those establishment Republicans and major donors who've been trying to maintain their distance while not alienating the MAGA base are now worried sick about being associated with someone who can't win a single appeal. Meanwhile, the hardcore Trump loyalists believe anyone who questions the legal strategy isn't MAGA enough, and that Trump's lawyers should just keep fighting no matter what courts say. Things became even more intense when Mitch McConnell, one of Trump's most complicated allies, made carefully worded comments to reporters. McConnell had been walking a tightrope for years, supporting Trump when politically necessary, but maintaining just enough distance to preserve his own institutional credibility. He'd been pushing for a strong defense of Trump while privately expressing concerns about the legal exposure. Now, according to Politico's sources, McConnell has privately told colleagues that the coordinated appeals rejections are a very serious development, and that Republican senators need to prepare for multiple scenarios regarding Trump's legal situation. When someone as politically calculating as McConnell starts hedging his language and preparing contingency plans, you know the situation has gotten dire. The coordinated court rejections have also triggered something unprecedented. Multiple federal judges felt compelled to include additional commentary beyond the basic legal rulings. Judge Kethledge's opinion included a section specifically addressing the proper role of appellate review that read like a judicial warning shot. He wrote that the appeals process exists to ensure that trial courts correctly apply the law, not to provide defendants with unlimited opportunities to delay proceedings through repetitive filings lacking in substantive merit. That's remarkably direct language for a federal appellate opinion. The judges went out of their way to explain that they weren't just rejecting these specific appeals, they were sending a signal about future filings. Judge Keenan's opinion in the Fourth Circuit included similar language, noting that continued filings of this nature may result in sanctions under Federal Rule of Appellate Procedure 38, which allows courts to award damages for frivolous appeals. That's legal speak for, we're about done with this nonsense, and next time there might be consequences. The courts were coordinating not just their rejections, but their messaging. The delay game is over. Legal experts from across the political spectrum are noting that we haven't seen federal appellate courts this unified in pushing back against a defendant's delay tactics since the final stages of the Watergate prosecutions. George Conway, a conservative attorney and frequent Trump critic, appeared on CNN and stated bluntly that when you lose appeals this badly across this many circuits with this kind of language from the courts, it means your legal position is fundamentally unsound. These aren't close calls. These are courts telling Trump's lawyers to stop wasting everyone's time. But here's what really caught attention. Former Trump administration attorney Ty Cobb, who's defended Trump in the past, went on CBS and said something that should make everyone take notice. Cobb stated that the appellate courts are signaling very clearly that they view these filings as abusive of the process. That's devastating for the defense because it means future appeals will be viewed with heightened skepticism. Trump's legal team has burned their credibility with the courts. Just think about that for a moment. This is coming from someone who worked in Trump's White House, who has every incentive to stay on Trump's good side. And even he's acknowledging that the legal strategy has collapsed. When your own side's former lawyers start using words like devastating and burned credibility, that's when you know things are bad. So let's break down what this coordinated rejection really means, because it's not just a compelling legal drama. It has serious consequences for how our judicial system operates and for the 2024 election. First up is the immediate political fallout. Trump is already facing significant challenges due to his four indictments, his civil fraud trial in New York and his defamation cases, and his favorability ratings among independent voters have been underwater for months. Republican strategists are getting anxious about the 2024 general election, which is definitely adding to the tension within the party. Now he's got federal appellate courts across the country essentially calling his legal strategy frivolous and designed to delay justice. And honestly, that's not the best look for someone trying to present himself as a victim of political persecution. Most Americans have a good deal of respect for the federal judiciary as a vital part of our constitutional system, even if they don't always agree with specific decisions. When courts across different circuits, including judges appointed by Republicans, all reach the same conclusion that your appeals lack merit, that undermines the persecution narrative Trump has been building. Democrats and never-Trump Republicans are definitely planning to take advantage of this situation. They'll argue that Trump believes he's above the law, that he has no respect for the judicial system, and they'll have these appellate court opinions backing up those claims. This is going to be Exhibit A in proving that Trump's legal problems aren't political persecution. They're the legitimate consequences of his own actions. You can expect to see these court opinions, and especially the frivolous language, popping up in Democratic campaign ads, speeches, and debates throughout 2024. Now, let's touch on what this means for the judicial system itself and for American business confidence, which is where Warren Buffett's intervention becomes so significant. Buffett has been extraordinarily careful over his decades in the public eye to avoid wading into political controversies that might harm Berkshire Hathaway's business interests. He's commented on tax policy, on economic issues, but he's steered clear of directly criticizing specific politicians' legal strategies. By breaking that pattern and explicitly connecting Trump's legal tactics to broader concerns about rule of law and business confidence, Buffett is sending multiple signals. First, he's telling the business community that the court's coordinated response should be viewed as the system working, not as political persecution. Second, he's signaling that major investors view legal unpredictability and abuse of judicial processes as threats to the stable business environment America depends on. Third, and perhaps most importantly, he's giving cover to other Republican-leaning business leaders and donors who've been uncomfortable with Trump's legal situation but hesitant to speak out. When the Oracle of Omaha says the quiet part out loud about rule of law mattering to economic confidence, that reshapes the entire donor landscape. Republican megadonors who've been sitting on the sidelines now have permission from one of capitalism's most respected voices to factor Trump's legal problems into their 2024 calculations. This situation also shines a massive spotlight on a core principle that's supposed to define American democracy, that nobody is above the law, regardless of wealth, power, or political position. At the heart of this issue is whether a defendant can just flood the appeals system with meritless filings whenever they want to delay accountability. If Trump manages to delay all these trials past the election through sheer volume of appeals, despite courts calling those appeals frivolous, it sends a dangerous message about our two-tier justice system. For 250 years in American democracy, the appeals process has been designed as a safeguard against trial court errors, not as a delaying tactic for wealthy defendants. The principle is that everyone gets their day in court. Everyone can appeal genuine legal errors, but nobody gets to abuse the process just because they can afford armies of lawyers. If that principle erodes, if the appellate courts allow themselves to be gamed by defendants with unlimited resources, then we're saying that justice really does depend on how much money you can throw at delay tactics. That fundamentally undermines public confidence in the entire legal system. But Trump has always been uncomfortable with those constitutional limitations on power. He craves total control over every institution that affects him. He wants a Justice Department that protects him, courts that rule in his favor, and an appeals process that delays indefinitely whenever convenient. If the courts had allowed these delay tactics to succeed, That would have been a significant boost to unchecked executive power, and it would have opened the door for future presidents and wealthy defendants to abuse the appeals process the same way. Each time someone with resources and power brushes aside judicial norms, breaks procedural rules, or floods courts with meritless filings, it weakens our entire system of justice. It starts making behavior that used to be completely unacceptable feel normal. Think about it. If Trump can file appeal after appeal that courts call frivolous without facing sanctions, what's to stop the next wealthy defendant from doing the same? If someone can just delay trials indefinitely through sheer volume of filings, what's to prevent the appeals process from becoming purely a tool for those rich enough to afford it? These questions don't just disappear when Trump's cases conclude. They become part of our legal precedent and our political culture. Looking ahead to the 2024 election, it's clear that all of this is going to have massive effects. We're still more than a year out from Election Day, but the narrative being set now will absolutely influence how independents and swing voters view Trump's candidacy. If the story that unfolds over the next 12 months is one of Trump battling every court in the country and consistently losing, with judges using words like frivolous and lacking in merit, that spells serious trouble for his general election prospects. Voters usually don't reward candidates who appear to be running from accountability. They want leaders who project strength and competence, not defendants whose own lawyers are getting publicly rebuked by courts. Right now, Trump isn't offering either of those qualities, so expect Democrats to champion a message focused on restoring normalcy, respecting institutions, and moving past the chaos. After years of constitutional crises under Trump, there are plenty of moderate Republicans and independents who believe that voting for someone else, anyone else, means the country can finally move forward. They're promising no more daily court battles, no more attacks on judges, no more testing the limits of executive power, just normal governance. That message might just resonate deeply with exhausted voters, including some traditional Republicans who've stuck with the party through everything but are looking for an off-ramp. So, here's the deal. Donald Trump just watched his entire legal delay strategy collapse in spectacular fashion, with 3 federal appeals, courts simultaneously rejecting his filings in language that borders on judicial contempt. This isn't just one politician's court troubles. It's about whether the appeals process can be weaponized by defendants with unlimited resources, whether courts will hold the line on abuse of judicial procedures, and whether Warren Buffett's public intervention signals a broader shift among Republican business leaders away from Trump. If these trial courts move forward now with proceedings, Trump is looking at the possibility of being an active criminal defendant during the heart of the 2024 campaign. That would mean competing in primaries and potentially a general election while prosecutors present evidence, witnesses testify, and the daily news cycle is dominated by courtroom drama instead of campaign rallies. It's about so much more than just legal strategy. It's about whether we genuinely have a judicial system that applies equally to everyone, or whether we've entered an era where wealth and political power can game the appeals process indefinitely. So, keep your eyes on this, because what happens in the next few weeks will be absolutely crucial. We're watching multiple trials potentially move toward actual start dates, watching Republican donors reassess their 2024 commitments, and watching the courts draw a line on how much delay they'll tolerate. The stakes have never been higher, the judicial consensus clearer, and the political implications more unpredictable. This is just the beginning of what could reshape American politics and constitutional law for a generation.